but 100% never do this. If this is not on the record, the revenue department will come and take what is yours. Welcome, everyone. Welcome, welcome, welcome. What we're about to go over today is likely not what most of you assume it to be. What we're going to go over are some basic things that some might have already known and some maybe not so much. But we are going to bring everything together as a whole to now make it make sense. Let me open up my Word document here and share the screen. What most people deal with when it comes to, generally speaking, any type of court matters, to which the whole issue of child custody, child support is associated with. Even if this is something that you might ever have to not do. Maybe you have a family member or someone else, maybe a friend, that this might be useful for. And even if that's not the case, there are certain aspects about this that can be used in other affairs. All it takes is just a little bit of creative thinking. What most people deal with when it comes to any court matters or any type of administrative matters, aka pen and paper. No pen and paper is the court. No administration of things deals with how you arrange, establish, organize, and enforce what's written on paper. That is all these things are, whether they are Article 3 courts or legislative courts, which don't necessarily hold judicial power and are just there to filter cases arbitrarily as quick as possible without looking at the merits or enforcing it in law, regardless of what venue you're dealing with. Most people are always attacked from several fronts, but they don't realize it. The art of war tells you always attack on multiple fronts. They use this, and so must you. We're going to deal with the substantive law, and we will deal with the financial aspect also. The first point here is attack on multiple fronts. The basics is a must. Some of you, let me zoom this in, I don't think it's large enough. Some of you already know the basics, but it is easy to forget, especially for some who are dealing with child custody cases. There's a tendency for people to forget there are basics to be performed before you can get rid of the case. What are the basics? Good old constitutional challenge. You must always do this, because a constitutional challenge is how you evoke the issue of jurisdiction. The issue of jurisdiction comes in many forms, one of them being the well-known minimum contact. President defendant's constitutional right to due process and, quote, offends traditional notions of fair play and substantial justice. This concept of due process is the same concept that's entertained when you do something called a constitutional challenge hearing. What it is always assumed is that even if they, quote, don't have jurisdiction over someone, there's still minimum contact, which is the issue of what people introduce when they say there's no jurisdiction, or the issue of when people begin to use trust, which we will speak of here, because everything we're speaking of here intertwines with trust. Many have heard of minimum contact, but I don't think they comprehend it. They know it deals with jurisdiction, but might not be too clear in the fact that minimum contact itself already assumes that you don't belong to the jurisdiction, as we've just read, aka non-residents. But there is still something however so small, however tiny, that might still tie you to that jurisdiction. Hence, the court can gain personal jurisdiction even if that man or woman is outside of that jurisdiction. And if you notice the reading of minimum contact and the violation of due process, that if you are deemed a non-resident who do not have minimum contact, then due process is violated. This is where constitutional challenge comes in. This is where you kill the entire assumption of jurisdiction and minimum contact by invoking the very basics called constitutional challenge. So on the one hand, you can say the court does not have jurisdiction, which can be true. But if in any matter, before we even start going into the complex aspect, one second, let me see if, okay, we're not here yet. The party raising an affirmative defense has the burden of proof in establishing that it applies. 1 second, let me email them real quick. The party raising an affirmative defense has the burden of proof on establishing that it applies, which is where the rule of evidence comes in. How it applies, we will go over very soon, or as we go over this. Raising an affirmative defense does not prevent a party from also raising other defenses, meaning you doing an affirmative defense does not prevent you from doing other things. In other words, there are more ways to skin a cat, and you can use them all to your advantage. There are some disputes as to whether certain defenses are actually affirmative defenses or just standard defenses. In court cases, is that they're told, okay, if you don't want to give us filing fees, aka administrative fees, which by the way they also use for slush fund, then do an informal paupers because it's your right to. But most don't realize that this informal paupers extend far beyond not paying filing fees. The declaration of informal paupers is also designed and can be used as an extension of evidence, absent of the limitation of saying, I don't want to pay filing fees. The fact that you can use it to not pay filing fees means you can use it to not be financially liable, so long as certain other attributes are involved, which is based on real evidence. Informal paupers is a Latin term meaning in the manner of a pauper. A suit brought in formal paupers allows a poor person to bring the suit without incurring the cost of the suit. Have you ever heard them say, own nothing, control everything? People tell you, look, they're the brokest person you ever find, even though you know they have money. They are declaring to you how they engage in their financial status. Those who are wealthy always declare informal paupers, whether they do it through tax or otherwise. Those who are not wealthy always try to do the opposite of showing that they have something, because they've never had it. So they think showing people that they always have it is the key. But in reality, that only makes you liable, especially in the world where everyone just wants to take from you and never want to give, especially those who have created a guise of legality through proceedings administratively in pen and paper. Proceeding in formal paupers is not a right and is subject to the discretion of the court. Proceeding in formal paupers is not a right and is subject to the discretion of the court. The discretion is what evidence do we have otherwise to prove that you are not a pauper, meaning you are not poor. Courts are authorized to allow plaintiffs to file suit in formal paupers by 28 U.S.C. 1915. Bringing a suit in formal paupers is available for both district court claim and appeals. Informal pauper suits are most commonly brought by prisoners. Most commonly, and this is how most people know how to use it. However, due to 28 U.S.C. 1915G, which speaks of how prisoners are to present cases, a prisoner is prohibited from filing informal paupers if they had previously filed 3 unsuccessfully informal paupers lawsuits, dismissed for being malicious, frivolous, or failure to state a claim. In other words, they give you a particular example of the most common aspect and the reason why it doesn't work, which is based on evidence to prove otherwise that they have the ability to perform. The performance that most people restrict this to is filing fees. Filing fees. But filing fees is not the restriction of how informal paupers can be used. The beautiful thing about pen and paper is it becomes something else in terms of what you call it, but the function of it remains the same. So under any circumstance, but 100% never do this. If this is not on the record, the revenue department will come and take what is yours. Any other party who says they want to take something from you will come and take what is yours. And guess what? This also applies to issues with IRS. You should declare that you do not have the capacity to satisfy something. However you declare it is up to you and how you want to finagle it. Certification of trust is assumed to be true and correct by virtue of you merely presenting it to them. If a person has actual knowledge that the trustee is acting outside, a person has actual knowledge, meaning evidence, that the one designated to deal with the matter that's stipulated in the certification of trust as the settlor and the trustee is acting outside the scope of the trust, meaning the stipulation of the limitation of what the trust says they can do. And the actual knowledge was acquired by the person before the person entered into a transaction with the trustee or made a binding commitment to enter into the transaction. The transaction is not enforceable against the trust, but the only way that they can know otherwise is if you present more information that you need to, and you will definitely not be doing that. A person who in good faith enters into a transaction relying on a certification of trust may enforce a transaction against the trust property as if the representation contained in the certification are correct. In other words, everything you put into the certification of trust must be strictly to your favor because it is assumed to be true and correct just by your mere interpretation reasonable. Has the Congress directly addressed the issue? If the Congress has determined whether the statute is vague or not, which Congress rarely does, because if a statute is vague, that's the judgment of the Judicial Department, the Supreme Court, to interpret legislature. So rarely will Congress, aka the legislative department of the government, ever do so. The only thing they would ever do when it comes to something that was deemed ambiguous is say we omit it because it's unconstitutional because of a Supreme Court case. That's what they will do. The only other time that they would address it is if they are lobbied for that verbiage to be constructed in a way that favors any type of big corporation. And most big corporations will in fact lobby Congress to make it ambiguous so that those same big corporations and their federal agencies can then use the Sharon Doctrine to interpret it. Can only be given to someone by the party involved, which is you, one way or another. Most people, whether they realize it or not, within all the form they fill out, they submit this information at the preliminary stages, and they don't even realize it until it is too late because it's just a minor thing that they're just herded into doing it in a very subtle way. Just, just do this, just do that. It's fine. It's all right. They don't know the detriment of it until it's too late. But even after it is too late, you can just change it. And when it is changed, the Social Security Administration does not inform all third-party debt collectors of it. And the good part is the Social Security number compared to, say, the passport, whereby if someone owes a certain amount in child support or has some type of felony, the passport Secretary of State personnel would scrutinize it and say, okay, we don't want to issue this because you have child support that exceeds this amount. And it might be a flight risk. The Social Security Administration, they don't look at that. So the first step you can do is change that Social Security number. If you know all the affirmation things or things that you get to really comprehend, here's one way you can go at it. That's the first step. So what does the Department of Health, Education, and Welfare has to say about changing an actual Social Security number itself? Let's read it. That exception, only one account number will be assigned to an employee. Only one account number will be assigned to employee, except for this exception. When most people apply for the Social Security number, they fill out the well-known form that most people have seen on the internet. Your local office, your regional office of Social Security Administration completes that. When you want to change, which is an exception to being stuck with that one number that's being used to your detriment, go to the Social Security Board. It is ironic to discover, though logical and understandable in retrospect, that the first step in the process of extending the use of the Social Security number beyond the purpose of the Social Security program was taken by the Social Security Board itself on January 15, 1937, after the Social Security Act was passed. A question arose about an account numbering system to be used by state agencies. These state agencies, following 1937, are not just limited for the purpose of Social Security, which is in case something happens so that you retain social stability and keep your morale as an upright, proud citizen. We will support you because you know you've paid into this pot. So there's an employment insurance program. In today's world, what was sold to people for the purpose of Social Security number is not what that number is being used for anymore. In today's world, I'm letting you know, contracts exist by the people who are hiring people to mandate the use of Social Security, not for the purpose of unemployment benefits, but for the purpose of slush funds, and as a way to agree to third parties who want to come and take from you. But what you can always do is go through a backdoor, which is an exception, which is to change that number at any time by going to the Social Security Board. Whenever the issue of child support is involved, what you would always find is that there would always be a state actor using governmental powers as a state agency, quote, based on the revenue department to garnish the monies, or federal agencies to garnish the monies. Simple solution for those who don't have a 508 bank account is to change that social security number. Well, there's a policy on how that is done. One moment. Just give me 1 second. Let me go get some water. You'll be put in for a change request of social security number if you want to go this route. Is a religious reason. When I say many people don't know about how their system works, this is one of the things that I refer to. Those who have bad record with social security number for whatever reason, people look at it from a limited perspective of credit. Some people go and do bankruptcy. You don't even need to do bankruptcy. If you recall earlier, we asked, well, should you do bankruptcy? No, just go change the social security number. Do it for religious reasons. Note, if a new social security number is likely to contain a 666, your state has an area group configuration such as 056 to 666, blah, blah, blah. Route the material as indicated in D below. Print second social security number request special force red, so and so. Key here is always use religious reasons. If you have an attorney in any case, on behalf of the state of so and so or on behalf of a spouse, you can type their name here. Or you can type the name of that acting judge here. It will come up. It will show you who they've spent money with over any particular given period of time. Another resource you can use, the website called followthemoney.org. This first website we looked up was, let me show it. It's called opensecrets.org. opensecrets.org. So say the name of your acting judge is Thomas Corona. It will show you who they are, whether they are the candidate who received the money, who employed them, what job they had, what date they received the money, and the amount they received. Even if this amount is $1, which jurisdiction they received it, whether it's federal, whether it's from states such as Arizona, Carolina, whether it's New York, Rhode Island, blah, blah, blah. It would show it to you. It does not matter even if it is $1. If you find the name of that active judge or the name of that lawyer involved in that case with that acting judge, you can take this as evidence of remuneration and conflict of interest that violates the code of conduct. Something called supplemental income is what supplemental income is, a legalese term for slush fund. And contribution and donor is how they get those slush funds. And this is how you find it. Once you find it, you will take an image of it and say, hey, this attorney contributed to this acting judge's campaign during this time, this amount. And according to the code of conduct, any type of attorney that's given money to an acting judge, whether in the past, present, or future, if you don't have a physical location of those places and you want to use a mail forwarder, is to get whoever's name is doing that mail forwarding to do business as that as legal's name, and then provide that business document of whatever name you get in the ITIN in as their business, so that you can receive the ITIN information there or associated with it there as a